without further ado, I'm excited to introduce our two speakers for today's program. Natalie Harris is a partner at Barron Harris Healy and a defamation defense specialist. She has litigated numerous defamation cases throughout Illinois and Wisconsin, invoking First Amendment and combating efforts to silence protected speech through weaponizing litigation. Kim Schatz is a certified domestic violence counselor with SHALVA. She began her career as an attorney in the public sector, representing victims of domestic violence in civil proceedings, and was the clinical legal director at Pro Bono Advocates. We are excited to hear these speakers in conversation today. In both our professional work and personal lives, we need to consider the best way to support survivors in our community. Our goal for today's program is to give you greater awareness of the nuances of this issue. Without further ado, I'm going to turn it over to Natalie.
Great. Thanks so much, Vicki, for the lovely introduction. And thank you, Kim, for joining me in conversation today. I will share my screen. I have some slides here that I'm going to go through. And as Vicki said, I'm a defamation defense attorney. I always like to make that clear. I do not bring affirmative claims against anyone. My bread and butter is defending the right to speak the truth and to speak your opinion. So my background and my experience is in defending speech, and often speech close to the line that often offends people, gets people angry, which is when it winds up in litigation. So let me share my screen here. Bear with me just a second. Okay. All right, there it should be. So what we're going to talk about today is weaponizing defamation litigation and using it to silence survivors. So I'm going to start to talk about what is defamation, because sometimes I think it's not clear, it's bandied about a lot. And then I'm going to give a couple examples that I have some connection to of how it's been used to silence survivors. And then I will hand off to Kim to give her perspective on the weaponizing of defamation as well. So let me get started here with substance. First question, what is defamation? People have probably heard of slander and libel. Slander is, as my little icon shows there, oral defamation. So we'll talk more about what it means for a statement to be a defamatory, but if it's oral, it is slander. If it is written, it is libel. The good news is in Illinois, you don't have to care much about the distinction because they have been joined under umbrella. So the combination of either oral or written statements is referred to under the umbrella term of defamation. I'm going to walk through the elements, and I'll try not to be a boring lawyer as much as I can and give some examples, but I think it's important to have an understanding of what somebody on the plaintiff side, and for today's purposes, that would be a perpetrator who's looking to silence a survivor for speaking out. What does that perpetrator have to be able to put in his papers in court to do what's called state a claim for defamation? So the first element, which is how we break down claims in the legal world, is that the statements at issue must be provably false as distinguished from opinion. And I can tell you there, you could have weeks of law school class on distinguishing fact from opinion, and it's highly nuanced, but I'll just give you a sort of ripped from the headlines example from over the summer that I think is helpful in understanding the difference between something that's a legal fact or a legal opinion. So you guys may be familiar with this photo. This gentleman here is a guy by the name of Nick Sandman, who was a student at Covington Catholic. This gentleman here is a Native American by the name of Nathan Phillips, and they had a confrontation on the National Mall, which went viral, as you may recall. And following sort of the viral video, there were a lot of publishers, print publishers and otherwise, that wrote stories about the confrontation and what happened. Several biggies, including the Washington Post. And the Washington Post, in writing the story on the confrontation, wrote in one of their pieces the soundbite that they had received from this fellow, Mr. Phillips. Mr. Phillips told the reporter from the Post that during this incident, he felt that Sandman, this guy, had blocked him and wouldn't allow him to retreat. That was the statement that he made and the statement that the Washington Post published. So Sandman and his attorneys filed suit against the Post, and they claimed that that statement that the Post had published conveyed that Nick had assaulted or physically intimidated Phillips and engaged in racist conduct. So this case went on for a long time. It was not dismissed out of the blocks. There was discovery taken, which is the back and forth of questions and taking of depositions. And at summary judgment, thankfully, the Washington Post prevailed. And the judge indicated, this is ripped from the opinion, the court concludes that Phillips' statements, this gentleman, that Sandman blocked him and wouldn't allow him to retreat, are objectively unverifiable and thus unactionable opinions, meaning that's protected speech. In other words, what the Washington Post was doing was reporting Phillips' opinion of what happened during the confrontation. And therefore, Sandman's efforts to sue the Post for defamation arising from those statements could not stand. They are not actionable because the speech at issue is not verifiable fact. It was opinion. Number two, the statement must have a defamatory meaning. And what does defamatory meaning mean? Big picture, it means harm to reputation. In Illinois and many states, there are some magic categories of statements that are automatically harmful to the reputation. They're known as defamation per se. And I will warn you that some of them are sort of archaic and offensive, candidly, but they are what they are. And three of them tend to be most of the sort of cases I see, and the others, thankfully, have fallen more by the wayside. So those categories include statements that impute the commission of a crime. I'd say the vast majority of cases I defend, the plaintiff's argument is that whatever it is the defendant said, and this would make sense in the assault context or the abuse context, imputed that the plaintiff committed a crime. Can't be any crime. It's got to be a crime of moral turpitude, punishable by prison. But for most cases in this realm anyway, a statement like that would qualify. The other categories, these two are sort of related. They have to do with someone's profession. One is referred to as lack of integrity in profession. If you're dishonest, sort of a cheater or a stealer in your professional realm. And the second one, lack of ability, is more you're no good at it or you demonstrate you're not the right fit for it, a drunken teacher, that sort of thing. The other two categories are the old-fashioned ones. One's a loathsome disease, and you can imagine how these were sort of used against women back in the day, right? If you've got a venereal disease, etc., that's why it was characterized as something that automatically harms your reputation. I don't know that that's so true anymore, but it still exists, although I've never in my life seen a loathsome disease case, although perhaps monkeypox will spring those back to life. And this one, even more ridiculous, statements that impute fornication, which is sex out of wedlock. Again, I have seen a fornication case. There's actually a really prominent, we call it a slut case in Illinois, where referring to someone as a slut arguably could be considered defamatory. I have another opinion about it, but anyhow, those are the major categories of statements that are characterized as defamation per se. The third element of a claim is that the statement can't be privileged. And this is a policy-based argument. In other words, these privileges were created so that people will be encouraged to be candid and forthcoming. So here are the different kind of privileges. So anything that you were to say in court, either in open court or in a deposition, in testimony, or with your lawyer, that is privilege. Those statements cannot be the subject of defamation proceedings. The same is true with a doctor or a therapist or someone, a similar health professional. Same is true when you're making reporting to law enforcement. So if you're reporting a crime, you're calling 911. And the same is also true in the course of an investigation. And this comes up often sort of in the course of like an HR investigation, if someone to make a complaint about somebody in the workplace environment and to accuse someone of having engaged in misconduct. Those statements about engaging in misconduct are privileged and therefore cannot form the basis of a defamation lawsuit. Fourth element is fault. That's basically the level of fault that the plaintiff has to prove. For a regular person, the barrier is pretty low. So if the plaintiff's just a regular guy, regular Joe Blow at work, or spouse or boyfriend, the standard is low. He's just got to prove that the defendant failed to take proper care in demonstrating the truth. If the plaintiff is a little bit more famous, a public figure, a public official, This guy is Jose Baez. He'll become more relevant in a bit, but he's sort of a lawyer to the celebrities. The standard for someone of his caliber is actual malice, which means that he's got a much higher standard. He's got to prove that the speaker either knew what they said that was false, or that they were harboring serious doubts about the truth of it at the time that they said it. The idea is that he's got a better ability should have a thicker skin and better access to the media to be able to sway opinion about his reputation. So his burden is much higher. And finally, you must be able to demonstrate damages. In Illinois, there's an idea of what's called presumed damages. In other words, you don't have to be able to show that you've lost $1 based on the statement. The presumption is that you have, if it's defamatory per se, if it falls into one of those categories. It is rebuttable, which means that the defendant can demonstrate with evidence that in fact that the plaintiff didn't suffer any financial damages, but it's very risky in Illinois, because if the plaintiff puts on a good show about having been, damaged, lost sleep, whatever it is, even if he doesn't have great evidence, the jury basically has a blank check to award damages. So it could be a dangerous situation. I'm going to pivot now to a couple of quick examples of how I have seen defamation weaponized against survivors. So this first one involves Rose McGowan, who you may be familiar with. She was sort of the first person to come forward as a silence breaker against Harvey Weinstein. And he really sort of did everything in his power to make her miserable and to terrify her, because he knew the story that she was going to tell. In any event, after the Me Too movement was well underway, Rose was picked up for cocaine possession. Allegedly, she had cocaine on an airplane when she was going to the Women's March. She claims that Weinstein's goons had planted the cocaine. In any event, she was charged and needed a defense, and she hired the celebrity lawyer, Jose Baez, who with his team sort of encouraged her to plead guilty and sort of move on from the case. And what she learned shortly after having pled guilty, but while still a client of Baez's, is that Baez had, behind her back, without telling her, joined Harvey Weinstein's defense team in the New York rape trial. She was obviously outraged that he hadn't disclosed that, and made a lot of statements to various publications and on social media. Here's an example of one of those statements. She said to the Daily Beast that Baez had a major conflict of interest. She said, "This is why my case didn't go to trial. My instinct was that my lawyers had been bought off. I thought Harvey would get to them behind the scenes, and I wouldn't have fair representation." So surprise, surprise, Jose Baez, who by the way now is also the lawyer for Harvey Weinstein, filed suit against Rose for this statement and several others that she made on social media. And the result, thankfully, in Cook County was that, here, I'll read this part. Baez is right to claim that an allegation of disloyalty or having been bought off could damage him as an attorney, but when read in the context of the statement, it is also opinion. She states, in the context of learning that her attorneys in her case, where she believes Weinstein had planted cocaine, were now Weinstein's lawyers, an opinion and feeling that my instinct was my lawyers had been bought off. So we won sort of for the same reasons that the Sandman case was dismissed against the Washington Post, and that what Rose said was considered an opinion and not a hard fact. So that was a good result, but it's also important to know that was an expensive result, right? Even though we were right all along, and Baez should not have, was not able to state his claim. At the end of the day, it took a long time, a lot of litigating, and a lot of money before we got that good result. Here's another example that I have. The image on the right is an article that was published on August 26, 2020. It was an expose of what was at the time the Washington football team and allegations of sort of misconduct in the front office. And an executive assistant formerly with the team was a source for this reporter, Liz Clark, and was saying things, having known quite a bit, that Dan Snyder, who owns the team, did not like. So in the interim, you'll see this is the 26th, before the article came out, and in an effort to shut that employee up about talking about inside business. And the employee, by the way, had been subjected to non-sexual but pretty horrible harassment herself while she was there. Snyder sort of manufactured a defamation suit based on a republication of some garbage in India and used that suit to file proceedings here in the United States to subpoena this employee's phone and all her records and everything sort of personal about her. And she was sort of faced with this giant federal litigation where this guy with all kinds of money and all kinds of power, who was accused of all kinds of horrible things, basically had carte blanche to look through every private thing on her phone ever. In any event, we came in and were able to resolve the matter amicably, but it's another good example of how men who perpetrate use the system to try and shut women up who are trying to give voice to what has happened. And this is my final example here. This is a clip from the Cook County Record. This is Richard Dent, who's a former Hall of Famer, Chicago Bears. He, in his post-Bears career, has an energy supplying company, and he had a relationship and engagement with Exelon/Constellation Brands, which is an energy company, and was attending various events for those companies here in Chicago, golf outings, that kind of thing. And there were reports that at those events that he sexually harassed at least one person and was engaged in some public drunkenness. Following that, there was an investigation. Witnesses gave statements about what they had seen, and his company was dismissed. The contract was terminated for misconduct. After that happened, Dent filed suit in Chicago trying to seek the identity of the witnesses internally who had made statements about him, accusing him of sexual harassment, for the purpose of being able to name those people as defendants in a lawsuit and sue them for wrecking his reputation and forcing the breakage of the contract. The good news is this went up to the Illinois Supreme Court. That's not good news that it took that long and that much money. But at the end of the day, the conclusion was that the context of the sexual harassment investigation was in fact privileged, and therefore he was not entitled to learn the identity of the people who had made the statements about his misconduct. I will say he has filed a petition for rehearing, which is currently pending. So the story is not completely over, but I suspect that it will go in a good direction. So with that, let me give Kim the mic. I will stop sharing here and we'll come back when she's finished, and I'll talk a little bit more about what you can do if you find yourself in this position.
Okay, Kim, I'm gonna share my screen now. So we can, actually, this isn't the right one. Hang on. Sorry, guys, give me half a sec. Let me just get the right one up. Okay. Arg. I can't get out of here. I can't get out of here. It's not liking me. Is that weird?
Yeah. I can share my screen.
Why is it?
How did I share my screen?
Okay, guys, sorry. We're gonna do this differently because my computer is being weird.
All right.
Can you guys see this?
Yep.
Great.
All right, are we all set?
Yep, go ahead, Kim.
All right, perfect. All right, so
Can you guys hear me?
Yes, Vicki, we're all set.
Okay. So I've been tasked today with talking a little bit about the significance for survivors of being able to speak out and share their stories and the legacy of celebrity cases. All right, if you can switch to the next slide for me, that would be great. All right, so I'm going to spend just a little time today speaking about the experience of survivors who choose to share their stories. But before I do that, I want to start with just a few statistics on, one second. With just a few statistics on the prevalence of abuse. All right, these statistics were compiled by the National Coalition Against Domestic Violence. All right, so 1 in 4 women and 1 in 10 men experience sexual violence, physical violence, and or stalking by an intimate partner during their lifetime, with the impact being concern for their safety, PTSD symptoms, injury, or needing victim services. All right, you can skip to the next slide. Approximately 1 in 5 female victims and 1 in 20 male victims require medical care. Female victims sustain injuries 3 times more often than male victims. 23.2% of women and 13.9% of men have experienced severe physical violence by an intimate partner during their lifetime. And if you can skip to the next slide. According to the 2015 US Transgender Survey, more than half, or 54% of respondents, experienced some form of intimate partner violence, including acts involving coercive control and physical harm. So from these statistics, we can see that while both men and women do experience intimate partner violence, the prevalence remains highest among women and transgender individuals. And as such, for the purposes of this presentation, you're going to hear me primarily use the pronouns she and they interchangeably. All right, so let's talk about survivors who share their stories. Interestingly, as I was preparing for this presentation, this quote actually happened to come across my Facebook feed. So I just wanted to share it as I thought it was particularly apropos. Okay. Words can be action, and for people who have been denied a voice, they can be revolutionary. And that was written by Sherry Linden in The Hollywood Reporter. Right. For many survivors of intimate partner violence or sexual violence, the pain of trauma is often experienced in isolation. Even after escaping from an abusive relationship, many survivors choose to remain silent out of numerous fears. Many survivors fear they will not be believed. They may fear ongoing safety and legal concerns. Many remain silent as a result of the shame and guilt they carry, oftentimes being conditioned by their abusers to believe they are at fault for the abuse. It takes an unthinkable amount of trust and vulnerability for a survivor to disclose their experiences. Now, for some clients, however, sharing their story publicly actually becomes a necessary and therapeutic part of their healing process. A support group, for example, can provide clients with a community of survivors who bear witness to their healing and serve to validate their strength. In fact, we know that connections with others can be vital for the healing and growth of a survivor of abuse. All right, next slide, please. All right. Many advocates have long recognized the power for women in sharing their stories. In 2006, Tarana Burke, an advocate for women in New York, first coined the Me Too phrase on her MySpace page. Now, Burke, as someone who experienced sexual assault, wanted to do something to help women and girls, particularly women and girls of color. who had also survived sexual violence. She had hoped to empower women who had endured sexual violence by letting them know they were not alone and that other women had suffered the same experience. In a later interview, Tarana Burke stated, "When I started putting the pieces together of what helped me was having other survivors empathize with me." In 2017, in response to allegations of sexual harassment against Harvey Weinstein, actor Alyssa Milano embraced the Me Too hashtag across her social media, tweeting, "If you've been sexually harassed or assaulted, write Me Too as a reply to this tweet." Now, at the time, Alyssa Milano had been unaware of the phrase's origins, thinking of it as a simple way to create awareness, find support, and build a community of survivors. But according to Twitter, following Milano's tweet, Twitter users posted that hashtag almost 1 million times within 2 days. The movement spilled over to Facebook too, where about 4.7 million users shared 12 million posts in fewer than 24 hours. In 2017, Tarana Burke stated, "It made my heart swell to see women using this idea, one that we call empowerment through empathy, to not only show the world how widespread and pervasive sexual violence is, but also to let other survivors know they are not alone. It's beyond a hashtag. It's the start of a larger conversation for radical community healing." And years later, people continue to share their stories with the hashtag #MeToo across social media. Next slide, please. All right, so for a survivor who chooses to share her story, there can be many benefits. And to be clear, the decision to share one's story is always up to each individual survivor. Abuse can leave a survivor feeling powerless in so many areas of their life. So it's really important that they feel in control of whether and how to share that experience. Okay, but here's some of the benefits of both the Me Too movement, as well as for survivors who do choose to share their stories. All right, so sharing lets other survivors know they are not alone. It empowers survivors to have a voice and take back control of their story. It raises awareness of the impact of abuse and educates people about the many aspects of the issues. It develops a strong community where survivors can have a voice and can connect with one another. It offers hope to other survivors in their own healing, demonstrates how widespread the issue is, paves the way for updated and newly enacted laws and policies, and allows survivors to break the silence. And finally, it destigmatizes the abuse and makes it safe for discussion. All right, you can switch to the next slide. At a recent SHALVA luncheon, SHALVA hosted a conversation with Stephanie Land, whose 2019 memoir, Made, Hard Work, Low Pay, and a Mother's Will to Survive, was adapted into the Netflix limited series Made. Made portrays a fictionalized version of Land's life, which follows Alex, a hardworking mother who is challenged with leaving an abusive relationship and struggles to survive in a system of safety net programs and government assistance that seems to fail her at every turn. Talking about her decision to come forward and publish her story, Land stated, "I really didn't think people would listen or care about my story because I had lived such an invisible life. There was a part of me that knew why they were listening. I mean, I'm a white person. I am a success story. I'm on the other side of things. We don't like to listen to people who are still angry, who are still in poverty, especially people of color. I kind of saw that happening leading up to it, and it terrified me. But I at least hoped that if they were listening to me, they would start listening to others, and it would open doors for more marginalized people to talk about their lives." All right, next slide. If a survivor does choose to speak out and share their experience, there are many ways survivors have done so and felt supported and validated. For example, they may choose to join a support group in their community or join one online. They can volunteer at a domestic violence organization or rape crisis center, where one story can be used to inspire other survivors. They may choose to tell their story through journaling or poetry. In fact, when it comes to building a voice, sometimes writing can be even more powerful than video or audio. And using activism campaigns, there are many innovative campaigns that allow survivors to tell and present their stories. For example, the Clothesline Project is an amazing project which allows survivors of violence to decorate a t-shirt, which is then displayed publicly with the shirts of other survivors on a clothesline as a way of demonstrating the impact violence has on our communities. All right, next slide, please. All right, so while Me Too may have paved the way for women to feel more comfortable sharing their experiences of harassment and abuse, post-Me Too, unfortunately, we are seeing survivors continue to face threats and retaliation for speaking out. So, all right, let's talk just a little bit about the Amber Heard Johnny Depp case. So what do we know? Well, in 2018, Amber Heard wrote an op-ed for the Washington Post in support of the Violence Against Women Act. And the pivotal 12 words in Heard's op-ed were, "Then 2 years ago, I became a public figure representing domestic abuse." Right. Based on this statement, Johnny Depp filed suit against his ex-wife, alleging that she had defamed him, despite the fact she never actually named him as her abuser. Now, the statement Heard published happens to be a true statement, but Depp claimed she could only make this statement because she had lied and faked her injuries, thereby engineering an abuse hoax across several years. All right, what we know is that legal actions are frequently used as a form of retaliation to silence and punish survivors who have left an abusive relationship and spoken out about their experience. Defamation suits, in addition to lengthy and ongoing family court litigation and additional civil and criminal suits, become a way for perpetrators to lock survivors into years of abuse. A lawsuit offers a perpetrator the perfect vehicle to further their control and power disparity in the relationship and maintain ongoing face-to-face contact. The goal for an abuser is simply to use the court system to control, humiliate, and further abuse the survivor. All right, if you can take us to the next slide. One of the most harmful results of the Heard Depp trial has been a reinforcement of the perfect victim concept. In other words, the idea that victims of abuse should look, sound, and act a certain way. The perfect victim stereotype is something that has been theorized in psychology since the 1960s and results in intense scrutiny over everything about a victim. Why is she crying? Why is she not crying? Why is her memory recall of some incidents unclear, while for others it's razor sharp? Why didn't she tell somebody about the abuse? Why did she cover her injuries with makeup? Why didn't she? All right, so what's the perfect victim look like? Well, the perfect victim is often portrayed as innocent. She doesn't drink or do drugs. She has a clear memory of her assault. She has corroborating evidence, but not too much evidence, because that would indicate she's vindictive and planned to speak out. The perfect victim comes forward reluctantly. She cuts off contact with her abuser as soon as the abuse takes place. She does no wrong at the office, in relationships, as a mother or daughter. She's never lied about anything ever in her life. She dresses appropriately, and ideally, she's virginal. And the reality is that that perfect victim does not exist. All right, next slide. Because the perfect victim does not exist, survivors constantly find themselves caught in double binds by the court system and by the narratives that are created by abusers to further abuse and invalidate a victim's credibility. Double binds are the catch-22s that often ensnare those who accuse their partners of intimate partner violence. And here are just a few examples. If she did not take photos of her injuries, the abuse didn't happen. If she did take photos, they're fake, manufactured, and designed to frame him. If she did not tell her family or friends about the abuse, she's lying. If she did tell family and friends, they're lying for her, they've been coached, and are part of the hoax. If she didn't seek medical treatment, she wasn't really injured. If she did seek medical treatment, her entire medical history can be combed and used against her as evidence that she's mentally ill and unstable. If she's ever minimized her partner's abuse, then it's not abuse. If she talked back or fought back, she's the real abuser. If she cries on the stand, she's overly emotional, messy, and hysterical. If she testifies with perfect composure, she's calculated and unfeeling. Okay. Amber Heard was painted throughout the course of the trial as a deceptive, overly emotional ex-wife who made things up for attention. That portrayal of women as overly emotional, attention-seeking, or mentally ill has long been used to belittle those who allege abuse. The truth is that intimate partner violence is messy and complicated. Survivors frequently stay with their abuser, fearing economic, social, or physical repercussions if they leave. They sometimes fight back, and they can be flawed. They don't need to be pure or sober to tell the truth. During the Heard Depp trial, Amber Heard faced frequent comparisons to the perfect victim and did not live up to that standard. In short, this is a verdict, a case study in how women who fall short of our expectations are disadvantaged in the court of public opinion and the court of law. All right, now, if you can flip to the next slide. I just want to mention real quick the role in this case also that media played, and social media and the internet played as a tool of abuse. In this case, there were two significant factors that contributed to the internet being used to humiliate, shame, and further abuse Heard. First was the judge's decision to permit cameras in the courtroom, and second, the decision to not sequester the jury. More than any other recent case, this trial highlighted the power of internet culture to influence a case and be used as a weapon of abuse. Despite a United Kingdom judge previously finding that Depp had abused Heard on at least 12 occasions, the internet court of public opinion fell on Depp's side, resulting in an explosion of anti-Heard content online. TikTok videos mocking her, YouTube videos claiming to debunk her account of events. Over the 6-week trial, the abuse was blatant and widespread. While on the flip side, Depp was portrayed as a hero. The Justice for Johnny movement seeped into every social media feed, including TikTok, Twitter, YouTube, and Instagram. Amanda Hess of The Times wrote, "I did not follow the defamation trial between Johnny Depp and Amber Heard. It followed me. Depp's prime motivation in bringing this suit was likely to embarrass and stigmatize Heard. The fact that he became a men's rights folk hero in the process may have come as a surprise even to him." All right. Abuse should never be a laughing matter. By transforming this relationship into memes and jokes, the internet succeeded in trivializing the abuse. A viral TikTok post with more than 222,000 likes wrote over a photo of Heard's bruised face, "He could have killed you. He had every right." This was a legal proceeding transformed into a public spectacle. Now, the fact that it was seen as entertainment or a big circus Not only does it show a massive lack of empathy for victims, but it may inform a victim's desire to want to come forward in the future. Survivors of abuse are so often told no one will believe you. Seeing a survivor harshly judged and nitpicked on the stand and by social media can have a silencing effect on survivors who may feel they don't match the perfect victim standard and be reluctant to come forward in the future, share their story, or seek help. While it's easy to dismiss the events that took place inside and outside the courtroom as celebrity drama, it's so much more than that. And the legacy of this trial has the power to inform and influence conversations about intimate partner violence and sexual violence for years to come. And I will turn it back over to Natalie.
Thanks, Kim.
Thanks a lot, Kim. I find that I've never done this before, balancing the way I see the world through legal eyes with someone who is a therapist is fascinating and helpful for me, and actually sort of dovetails a bit into what I'll talk about next. This was the most recent slide that we saw. But now I'm going to talk a little bit about what should I consider before speaking out. I can tell you this has been an evolution and a journey for me as well. I started my own firm with 3 longtime partners and friends a couple of years ago, but before that, I was part of a bigger firm, and almost all of our clients were, media. So, and we still have those clients today, but there were reporters that were part of a big paper or the TV station, and we were fighting over bad things that got said about, a nasty politician or a wayward doctor, that kind of thing. And when I started my own firm, I thought, there may be individuals out there who are facing the same kind of challenges in an intimate environment, but don't have access to the kind of defense that we've offered these big companies. And so I discovered the Time's Up Legal Defense Fund, which is administered by the National Women's Law Committee. And what they do is provide funding for women who, not just women, people who are survivors, victims of mostly workplace sexual violence abuse, but they have some flexibility. In any event, what it did is it gave me the opportunity to do work for a different segment of the population. Same issues, same legal arguments, but very different psychological setting. And it has taught me what it means to be a trauma-informed practitioner. Most lawyers, other than those who specialize in these kind of areas, are beyond horrible at that, in my humble opinion. And I will say I probably was too before I encountered doing this kind of work. But I think it's incredibly important for survivors to know that there are lawyers out there who understand what trauma does and who will view a case or the question of should I speak out from the point of view, not just of could you win eventually, is this a garbage case, but what does it mean to the person who speaks out if it does turn into a case? Even if you eventually win, what is that process like and what might it do to you? So I've learned a lot about that, and I'm going to talk a little bit about what I've learned. So one of the first things I would say in terms of what you should consider before going forward is just consider, right? Some of the most upsetting things that I've been involved with involve sort of an off-the-cuff social media post, right? That wasn't well thought through, that wasn't vetted, that is sort of vulnerable to attack from a legal perspective. So I think before anybody decides to tell a story publicly about someone who victimized them, a perpetrator, they should think long and hard about it and talk to someone who understands the legal risks and ask themselves, what is my why for speaking out? I have encountered a lot of women over the past couple of years who've said, I feel like I have to. This terrible thing happened to me at work. This terrible thing happened to me as I was apprenticing in the music industry. And I feel like it's my obligation. Everybody else has done it. It's on all the, headlines and covers, but I'm terrified of what might happen. I know my perpetrator is the kind of person who's going to retaliate viciously, and I just don't want to. I think it's important to find a lawyer or a counselor or someone with guidance who will say to you, that is okay. And that is important to recognize that you don't want to, because if you're feeling hesitant at the outset, you are likely not going to be well prepared to endure what will happen if there is bad backlash, and you are likely to be re-traumatized, which is horrible. So ask yourself, why am I doing this? For some people, the why is, this is really part of my healing. I absolutely want to, come hell or high water. I don't care what he does. I'm going to do it. And for that person, you're a great candidate. For other people, it isn't just as easy to figure out whether it's the right call. The other thing that you should consider is this idea of truth as a defense. I feel like a lot of people will say, well, isn't truth the ultimate defense? So you can't, be liable for defamation if it was true. That is true. It only has to be substantially true for you to be able to prevail. However, the way the system works is that you don't get the opportunity to prove the truth of a statement until very far down the litigation road. Many thousands and thousands of dollars have gone into a case before you get the opportunity to give evidence, give a deposition, write a motion to the judge that shows truth. And a lot of people don't understand that. So while a lot of cases are resolved on the issue of what's called substantial truth, the process from filing suit to a victory on substantial truth can often be months to years and thousands upon thousands of dollars. So that's important to keep in mind. And I'll also say that it always puts me in a weird position because I'm a defender of speech. That's what I do. I'm a First Amendment advocate. No matter how ugly the speech is, as long as it's not false and defamatory, I think you should be allowed to say it. That being said, I'm very cognizant of the fact that pressing people to say everything all the time is not always in the best interest of the client. Other things to think about is whether the perpetrator about whom you intend to speak out has connections to lawyers. Do they have the resources to find one? Often lawyers will take these cases on contingency. So just because the perpetrator doesn't have money might not matter. That's a real bummer because often perpetrators think, oh, she's such a liar. I'll hire an attorney and rather than fight me, she'll pay some money and that'll pay the lawyer and me. So if he's somebody who thinks that way, you should be cognizant of that because that could be damaging going forward. The other question is, do I have solid evidence? And I know, this is tough. This goes to sort of the perfect victim. Was she the best record keeper ever? If the answer is it's he said, she said, I don't have a lot of great evidence. I didn't, keep real-time notes, which most people don't. That's something to think about because that will become part of the case, this idea that you didn't keep them. And the other question in terms of resources for the perpetrator, does he have the resources to hire personal private investigators to, basically scroll through all your Facebook people, call everybody, tail you? That happens a lot. And if he is someone with financial resources, he could make the process really horrible. So after you make those initial considerations, if you think, you know what, yeah, I am the person for whom saying something is really important and good for me and good for others in general, you got to make sure you find the right lawyer. And it may not just be one lawyer. You might have someone who's working with you in the family law context or in some other kind of personal context in the relationship. But you should always also look for a trauma-informed lawyer who understands how defamation works. I happen to be one of them. There are others out there. You don't have to be a specialist, but you should speak to someone who understands the risks of defamation, who can do what's called vetting your content. In other words, if you want to, publish a letter or you want to speak to a reporter, it's important to have someone on your side who can help you generate the content, talk about the wording, talk about what evidence do we have to support this if it were to be pushed back against, who really understands kind of the push and pull of journalism and who can help you make good choices about what words to use, what photos to include, all those kinds of things to mitigate the risk, not only to you emotionally, but to you legally for put out content that is what we call pre-publication review and locked down as much as possible in terms of being libel proof. In other words, that you've covered your bases in terms of making sure that the content that is out there is less likely to draw a defamation claim. Another thing is to explore alternative resources. I will tell you that if you find yourself in this position, we have had great success. It is sporadic, but it happens for finding defense cost coverage in insurance. So if you've got homeowners insurance, sometimes even renters insurance, it would never occur to you that that would pay for a lawyer to defend a defamation case. Sometimes it does, depending on the wording of your policy. So you should have someone who understands insurance policies take a look at whatever kind of coverage you have, because you may be able to turn to that coverage to help you fund a lawyer. There are also organizations, as I mentioned, like Time's Up, that will provide funding to help fund someone like me to defend a defamation case that arises out of harassment or abuse, mostly in the work context. But as I said, they can be a little flexible about that. So if you find yourself served with a complaint in this context, there are resources, there are things that you can do to try and make sure that you shouldn't ignore it and that you find the right people to help support you. And this is consistent with what Jordan had said, but what do I do to prevent, as much as I can, a perpetrator from being successful in a libel suit against me based on something that I've said about the abuse? And, you know, you've probably heard this 1,000 times, but we call, in the journalism world, they call it have your receipts. So it's not actually receipts of stuff that you purchased, but proof of all the allegations that you're going to make for a statement that you're going to make about conduct that someone engaged in that's arguably defamatory if it wasn't true. You should have evidence. So you should save your text messages. You should, you know, save your photos. And again, there's the flip side, like Kim talked about, well, are you over documenting? In my experience, from a legal perspective, better to over document than not to have documentation. And I understand, and I have learned that the state of mind of someone when these things are going on is not to be a journalist to document everything, but to the extent you can in real time as you're experiencing it, shift your mindset a bit to understand that at some point in the future, I may need to recreate the scenario of what happened. Keep real-time notes to the extent that you can. Seek medical attention so that there's a record of what happened. Call law enforcement so that there's a police report. I can't tell you how many times, which I completely understand, that someone chooses not to do any of these things because it's terrifying. And I would never, ever say to someone that that was the wrong choice for them if it put them in danger. That being said, if doing these things like speaking to a friend in real time so that they can recollect what you said, creating reports, creating medical records, keeping track of what is happening to create a record is terrifying to you, that should be a message that speaking out until you're in a place where being able to record stuff is more comfortable may not be the right call for you. And so I'm going to close with this, which is again sort of the theme here today, which is the imbalance, right? In these kinds of cases, when they're in the public eye, and even when they're just sort of a regular court case that isn't on social media, I see this happen again and again and again when these kind of cases are in court, regardless of whether they're high profile or not. It's what I would call the legacy storyline for the perpetrator, right? That he's powerful, he's alive and well, and his whole point, and also you have to keep in mind who's sitting on the benches. It's changing, it definitely is, even from when I started practicing. But traditionally, it's been a lot of old white guys, right, who are inclined to believe other old white guys. Now it's getting better, but still, the history of believing a Johnny Depp over an Amber Heard is long, it's old, and it's stuck. And if you are in her position, you better be prepared for what I describe to people when I'm speaking to them on the phone, when they're talking about whether or not they should tell their story or whether they want to, you know, seek out a reporter. You got to prepare for what we call unceasing unfair scrutiny and recognize that oftentimes a perpetrator, even if they don't really have the resources, will find ways to really disrupt your life. Private investigators scouring your social media, making your life miserable and casting you with all these horrible things that Kim talked about. These are all words that I have had clients say to me as how this is what he's going to describe me as. This is how I'm going to look. He is the one who hit me. He's the one who was violent or drinking or, not going to work. I was managing the kids. I was doing everything right. And yet somehow his defense, when I say that, he engaged in misconduct, is that I'm all these horrible things. I wish we lived in a time where that was no longer the case, or where a jury or a judge can see through this instantaneously and realize what's going on, but we're not there yet. So anybody who is contemplating whether telling their story in a public way is right for them should really gird themselves and be prepared to understand that this is, yes, what you will face, and you should ask yourself whether you're willing to do that at this time. If you are, I would love more than anything else to defend your speech, which is protected and true, and I know that it is, and I will help you along the way when things get ugly. So
Amen.
that
Okay,
concludes.
thanks. I'm cutting you off only because we've got a couple great questions and we've got 2 minutes. And I think that we're gonna run a little bit over, and I hope that people will stick around because we've got a couple great questions. And I know Kim wants to talk a little bit about as a therapist, and this question really goes to you, I think, Kim. I think that Natalie did a great job explaining the legal issues that you need to consider going forward, and the personal issues as well, since she really is a trauma-informed attorney. But the question, Kim, is given all the potential repercussions for speaking out, why would anyone ever want to take that risk when the culture for women, as opposed to the power wielded by the male perpetrator, when will it ever be forced to change? So, Kim, do you want to kind of take that and maybe talk a little bit about how some of the psychological impact that you wanted to discuss?
Well, I think the reason that someone speaks out despite all of the ramifications is because they truly feel that it's part of their healing journey, and they truly feel that they can be a benefit to somebody else, and they're willing to take those risks. So much of abuse is spent in silence. And so being able to speak out, being able to share their story, being able to let other survivors know they're not alone is incredibly powerful for a survivor. And so even though there are these risks, and again, it's a very personal choice whether to come out and share your story or not, but I think that that decision to do so really feels like sort of a culmination of healing and a culmination of being able to find their voice and find their sense of power again and rebuild that sense of self. And it becomes part of their therapeutic journey. And so again, it's always a balancing act because many women know what they're going to be facing or potentially what they could be facing. So it's absolutely a balance, but I think it's when they feel that benefit outweighs the risks.
Great, thanks. Any other questions out there? Do you have any recommendations for trauma-informed lawyers in Illinois for other DV-related cases? I think call SHALVA offline. Give us a call. We may be able to help. Natalie, look up Natalie.
Wide network too of people who don't, practice in the media world, who I know who practice family law and other similar things. So you can always feel free to reach out to me as well.
Natalie, what's your website?
Vicki, can I just also say there are some amazing organizations in the Chicagoland area who provide low-income services for victims of domestic abuse. Lifespan is a wonderful resource. Legal Metropolitan Family Services has amazing resources. There's lots of resources out there in terms of finding trauma-related services.
I'd also say access. Ascend Justice.
Yeah, Ascend Justice.
I'm putting all this in the chat too. And then I've put in our website before, but Natalie, what's your website again?
My website is bhhlawfirm.com. So that's Baron Baron Harris Healy are our names.
Got that? It didn't go as a link, but people can cut and paste it. Oh, except I wrote Frim. Yeah. Oh, okay. Any other questions? Anything else you guys want to cover? I'm gonna, in these last few minutes, I'm going to put up a slide with our survey link. If I can share the screen this time without having my whole computer freeze. We'll see what happens. Here we go. Okay, let's see. Okay, I want to remind everyone to take a photo of yourself during today's program and be sure to post it. And here's the QR code. And the link is in the chat as well. Do we have any other questions? Let's see anything there. Kim, did you have anything else last minute to say? No?
No.
Okay.
Thank everyone for attending today.
Yeah, thank you so much. Oh, and I don't want to forget, I'm going to put that, our next program, we have another continuing legal education program coming up on October 27th. You can go to our website, shalvacares.org, under events to register for it. It's going to be on tips for obtaining and enforcing orders of protection. We have a great panel, including Judge Judith Rice, who is the acting presiding judge at 555 West Harrison, where orders of protection are heard. We also have an assistant state's attorney, a couple law enforcement officers, and a family law attorney who are all going to be talking about the issues involving orders of protection and some of those nuances that you may not think about. So it should be a very interesting program, and that will be in honor of Domestic Violence Awareness Month on October 27th. So please be sure to take a look at that. And I think that that's everything. So thank you both. Thank you, Natalie, and thank you, Kim, so much for speaking today. Thank you to all of you in attendance. Please take the survey. As I said before, attorneys in attendance will get their certificates in the next week or so. And thank you for being with us today and spending your lunchtime with us.
Thanks for having me, everybody.
Thank you.